Today we're diving even deeper into the ongoing legal saga between Justin Baldoni and the powerhouse Hollywood couple Blake Lively and Ryan Reynolds. In our previous coverage, we broke down how this dispute first came to light, the workplace harassment complaint filed by Lively, the subsequent backlash aimed at Baldoni, and the initial fallout both sides claimed to be suffering. Now, the story has evolved into an even more complex battle, one that has attorneys sparring in court filings and the media, as they seek to defend their clients' reputations and fortunes. Today, we're going to unpack everything that has happened since we last spoke, shedding light on the freshly filed court documents, the scathing attorney letters, the controversial behind-the-scenes footage, and the mounting legal implications for all parties. A major flashpoint in this ongoing dispute revolves around the request by Lively and Reynolds' legal team for what they are calling an appropriate protective order. This request is essentially a legal mechanism designed to limit or restrain public statements made by Baldoni's attorneys about the case. Lively's attorneys have argued that Baldoni's counsel has engaged in near-daily public statements, press releases, and interviews, behavior they feel could contaminate a potential jury pool. According to a filing obtained by multiple outlets, Lively's side accuses Baldoni's attorney, Brian Friedman, of giving television interviews, appearing on podcasts, issuing inflammatory written statements, and leaking information to the Hollywood press and tabloid media. This conduct, they argue, could prejudice the proceedings, making it impossible to select an unbiased jury when the case ultimately makes its way to trial. Baldoni's legal team, however, staunchly disagrees with the need for such a protective order. In a letter to U.S. District Court Judge Louis Lyman, Baldoni's counsel condemned Lively and Reynolds' motion as an overreach. They claim there is no valid reason for a court-ordered limitation on their public statements because, in their view, they have not violated any existing court rules. Baldoni's attorneys point to the rules that govern legal ethics in such situations, which, they note, permit a lawyer to make statements required to protect a client from the substantial prejudicial effect of recent publicity not initiated by the lawyer or the lawyer's client. They argue that Lively's original workplace harassment complaint and her subsequent interviews are precisely the kind of publicity not initiated by Baldoni, so issuing statements to defend him is not only permissible but necessary to counter negative press. This question of who is driving the media narrative has become one of the central sticking points in the conflict. Lively's attorneys maintain that her filing of a workplace harassment complaint is a protected action, one that falls under the broader umbrella of legal privileges granted to plaintiffs in harassment and retaliation suits. In a letter made public, they stated, making a complaint about sexual harassment and retaliation in a lawsuit, which is also a protected activity, is covered by the litigation privilege. On the other hand, relentlessly publicly attacking a plaintiff in a sexual harassment and retaliation case in the media and on social media is not a protected activity. From their perspective, the press statements emerging from Baldoni's legal camp cross a line between legitimate self-defense and a calculated smear campaign against Lively's credibility. According to Lively's team, they never sought a full gag order, despite Baldoni's attorneys claiming otherwise. Requiring counsel to heed the ethical rules that bind them is not a gag order. It is a mechanism that would ensure the proceedings in this court are not prejudiced by counsel's conduct outside of the courtroom, Lively and Reynolds' attorneys wrote. By their account, the simplest explanation is that they merely want to keep the case from transforming into a trial-by-media spectacle, arguing that the daily flurry of public commentary has started to overshadow the actual claims at the heart of the lawsuit. Baldoni's side, for its part, paints a picture of personal and professional disaster that unfolded the moment Lively's harassment complaint came to light, particularly after it was reported by the New York Times. They described the aftermath as utterly calamitous, claiming that Baldoni, along with Wayfarer Studios and all associated parties, instantly became objects of public scorn and contempt. Their legal filings allege that the negative press coverage has led to lost business deals, severed professional relationships, and reputational harm so severe that, as they phrase it, the Wayfarer parties have been exiled from polite society and suffered damages totaling hundreds of millions of dollars. From Baldoni's viewpoint, the legal counsel's public statements are a necessary counterweight to what they consider a scorched earth media campaign, orchestrated by or on behalf of Lively in an effort to preserve her own reputation. One of the most controversial developments has been Baldoni's legal team's decision to release a 10-minute video that shows behind-the-scenes footage of an intimate scene shot with Lively for the film. According to Baldoni's attorneys, this video directly contradicts Lively's description of his behavior on set. They argue that if the public can see the actual footage, they will understand that her claims are overblown or entirely unfounded. This move, however, enraged Lively's team, who blasted it as a stunt and a continuation of their harassment and retaliatory campaign. They also pointed out that releasing potentially sensitive footage to the public demonstrates a willingness to exploit private or semi-private moments for the sake of public relations, a tactic they deem unethical and designed to generate sensational headlines rather than serving the interests of justice. The question of whether this footage truly provides exculpatory evidence or whether it's merely a publicity strategy is now part of the larger legal dispute. If it influences public opinion in Baldoni's favor, it could also end up influencing potential jurors. This, according to Lively's lawyers, is the exact reason why they want a protective order. Baldoni's counsel is making near-daily attempts to sway public opinion and paint Lively as unreliable or untruthful, they suggest, and that's not how our justice system is supposed to work. Against this backdrop, a series of cease and desist letters have been exchanged. In December, Lively and Reynolds sent one to Baldoni's attorney Friedman, insisting he stop issuing defamatory and retaliatory statements relating to Miss Lively. Around the same time, Friedman and Baldoni's camp reportedly received a separate letter demanding that Baldoni and his associates halt any unlawful conduct toward the Lively Reynolds parties and their affiliates. These letters, it seems, did little to calm the conflict. Baldoni's team insists that they cannot remain silent while their livelihoods and reputations are being destroyed in real time. "We have a duty to protect our clients from ongoing public scorn," one unnamed source from Baldoni's side was quoted as saying in certain online forums discussing the case. Lively's attorneys interpret the situation differently, insisting that Friedman's campaign is precisely why they went to court, to demand an official protective order. Their worry is that Friedman's almost daily media statements or other releases to the press will contaminate the fact-finding process, making it nearly impossible to seat an impartial jury that hasn't already been swayed by months of media coverage. Friedman's conduct threatens to and will materially prejudice both the Lively case and the Wayfarer case by tainting the jury pool, states one of the court filings obtained by USA Today and other outlets. They argue that the best chance for a fair legal resolution lies in letting the court, not the court of public opinion, determine the outcome. Baldoni's side counters by saying that the legal principle of litigation privilege should protect them from claims of defamation when they are merely responding to or countering Lively's allegations. To them, the original complaint and subsequent interviews by Lively's attorneys triggered a tsunami of negative press. Their argument is that they did not provoke this wave of attention on their own, but are simply trying to restore public faith in their personal and professional integrity, which they claim has been unjustly shattered. Some observers have pointed out that this dispute highlights the tension between free speech rights, ethical rules for attorneys, and the integrity of the judicial process. In high-profile cases, lawyers often face a delicate balance, remain silent, and allow public narratives to run rampant, or speak up to defend their clients, potentially risking ethical boundaries. Meanwhile, the prospect of a settlement remains unclear. In many high-profile Hollywood lawsuits, parties will reach confidential settlements to avoid the intense spotlight of a public trial, which can reveal business practices, personal behaviors, and behind-the-scenes drama that neither side truly wants out in the open. However, given the acrimonious tone of the letters and the ongoing media blitz from both sides, observers doubt a swift resolution. Each side seems entrenched in its position, with millions of dollars, professional reputations, and personal pride at stake. Baldoni is looking to protect his career as a producer, director, and actor. Lively is defending her name and reputation in an industry where goodwill is currency. Reynolds, while less directly implicated in the day-to-day allegations, is deeply invested in supporting his spouse and maintaining the couple's carefully cultivated public image. The ramifications for It Ends With Us remain uncertain. A once promising film adaptation of Colleen Hoover's wildly popular novel, the project is now overshadowed by legal entanglements that could delay or even derail production. While many fans of the novel remain hopeful that the movie will eventually see the light of day, The behind-the-scenes turmoil and negative press could scare off investors, co-stars, or distribution partners. Some industry insiders have speculated that the film might need to find new producers or a new creative team if the situation can't be resolved quickly. Others wonder whether the controversies themselves might paradoxically drive interest in the film, making it an even bigger headline maker if it ever reaches theaters. Industry watchers also note the broader climate in which this dispute is unfolding. In the wake of the #MeToo movement, claims of harassment or hostile work environments are taken more seriously than ever before. For Lively, coming forward was presumably a move to address what she believed were legitimate grievances. For Baldoni, being accused of harassment, particularly in an era of heightened awareness, could be devastating to his career if he cannot publicly refute those claims. Both sides are fully aware of the high stakes, which is why the fight has become so vitriolic and why so many resources are being poured into legal fees, PR strategies, and crisis management. As of now, U.S. District Court Judge Louis Lyman has not issued a definitive ruling on the request for a protective order. Legal experts say that judges often prefer parties to come to an agreement on limiting public statements before imposing a restrictive order from the bench, as freedom of speech is generally protected unless there is a clear and imminent threat to the fairness of the trial. Nonetheless, judges do have the authority to enact such orders if they believe the integrity of the judicial process is at risk. If a protective order is granted, Baldoni's legal team could face restrictions, fines, or other penalties for continuing to make public statements. If the motion is denied, it would likely embolden Baldoni's side to continue their aggressive media strategy. This is where we stand at the moment. On one side, we have Blake Lively and Ryan Reynolds, who say they are simply trying to protect the legal and ethical process from being overshadowed by a public smear campaign. On the other side, Justin Baldoni and his production company Wayfarer Studios, along with other plaintiffs, maintain they are defending themselves against devastating allegations that have already cost them dearly. As the filings, videos, and interviews pile up, it's anyone's guess how this high-stakes legal battle will play out, or whether it can ever return to a strictly legal sphere without the prying eyes of the press and public shaping the narrative. If the case does go to trial, the discovery process could reveal even more behind-the-scenes detail, from emails and text messages to internal memos on the production of It Ends With Us. Depositions might feature key players in the production or even A-list witnesses, and those transcripts could become public if introduced in court filings. That scenario could further feed the media frenzy, making a quiet settlement an appealing option for both sides. Though, as of yet, there's no indication that either side is close to conceding or negotiating an end to the lawsuit. So, what happens next? We'll all be watching to see how Judge Lyman rules on the protective order and whether any new evidence emerges that might tip the scales in either direction. We'll also keep an eye on the public statements from both camps. Will they intensify their campaigns or step back and let the legal process unfold? Will additional witnesses or whistleblowers come forward? Could we see new lawsuits filed or existing ones dismissed? Only time will tell.